white, which makes it possible for the owner of justice to visit his farm and be there. One may also say that that provision was made to protect the person who is the subject matter of the trial.
Right.
Some people say, oh, it's such a high office and so on and so forth, that whatever happens should not be washing dirty linen in the public and so on and so forth. But first and foremost, the dirty linen has already been washed in the public.
Absolutely, by the fact that you've been accused of...
Exactly. All manner of things.
Right.
So, if it is for the benefit, that's why I'm talking about a purposive interpretation, which the Supreme Court has seriously taken account of, since this was actually first hammered by Professor Justice Dateba. It's a very, very important because it goes to the root. Right. It makes you understand why the provision is there at all, and for that matter, the application thereof. So, it may be said that it is there for the benefit of the Chief Justice on trial. I don't want to talk even about a particular person. Whoever is the Chief Justice on trial. But as I said, the matter is already in the public realm.
It is. Indeed, people are even referencing the exact issues against her.
Exactly.
And so, the secrecy aspect is already broken.
It's broken. If that is so, then the purposive interpretation should enable you, the beneficiary thereof, to now say, I don't want a secret trial. I don't know the position of the Chief Justice. I am talking in terms of jurisprudence and analysis. I don't know. But in that case, the Chief Justice, whoever the Chief Justice is, should be in the position now to say, I don't want a private trial. I don't want 5 people to go and put me in a room and come out and say, I'm guilty of all counts. I want the people of Ghana to hear what I have done and whether I am guilty or not, though so pronounced.
So basically, your suggestion is that it should be the prerogative of the person facing this 5-member committee, in this case, suspended Chief Justice Gertrude Tokono, to demand that the entire process is broadcast to the hearing of the Ghanaian people.
Yes, because I'm saying, to whom does that provision inure? It's for whose benefit? You cannot do something for nothing. You cannot, and the basic rule in the law code is that you cannot put something on nothing for it to stand. And the whole concept of purposive definition is to give it meaning, to give it purpose. So I say the first purpose is the purpose of the public good, which is provided in black and white in the Constitution. It belongs to the public. It belongs to Ghanaians. If that is so, we cannot take it away from them. And because that too is also part of the Constitution. So if you put the two together, they don't really rhyme. And for that matter, one must go. And for that matter, the one that must go is the secret trial provision. That's what I'm saying. If you come to the other leg, that is, it is a human right of the person on trial that the dirty linen should not be played in the public. Therefore, let it be done in secret. Then the person turns around and says, I don't want that right. I will prefer that whatever you are going to do it publicly so that my church members may know whether I'm guilty or not. I don't want a secret trial. Furthermore, my good gentleman, the whole concept of trial in secret is a very serious matter.
Why?
Because it goes against the very foundation of justice.
Justice must be seen to be done.
Exactly. Justice must be done. Not only that, it must be seen. In fact, some people even add manifest. It must be manifestly be seen to be done. To be seen by who? That's a foundation of our legal system. The British, even though they don't have a constitution, so far as matters of open trial and trial by the ordinary course of the land, so far as this principle is concerned. They reduce this in the Magna Carta.
Right.
As for this matter, let us reduce it to writing, because it goes to the foundation of our society. We all know the history of this country. The public tribunals, the People's Court, how people were blindfolded, pushed into a room, dark room, and could not see their accusers nor their adjudicators. We have decried it, and we say we don't want that kind of thing anymore. Maybe it's an unfortunate relic of the bad old times, and people must seriously examine it again. And that is why we can give a purposive interpretation and say it is not congruous with the provision that justice belongs to us.